our kind of annual nuts and bolts dementia legal planning for volunteers CLE that we have. I have a very short kind of intro presentation that I'm going to go through really quickly just to talk a little bit about our dementia legal planning program. Hopefully you can all see my screen here. My name is Michael Terasaki. I'm the Pro Bono Council Manager. The Washington State Pro Bono Council is a group that works with the volunteer lawyer programs across Washington State. See if I can get there. There's 16 of us, they're county-based, and one of the things that we do is we partner with the Dementia Action Collaborative and DSHS to provide free dementia legal planning services for folks in Washington State. There we go. What is the Dementia Action Collaborative? That's an excellent question. It's basically a huge group of public and private partners that work together to try and put together and carry out the state plan for dementia here in Washington State. You can see kind of a list here of the different groups that we work with. One of the things that we're doing right now is actually coming up with a brand new dementia plan for Washington State. So if you're interested in that stuff, please kind of follow along, and there should be a new one coming through. Like I mentioned, this is our annual dementia legal planning for volunteers CLE. So there are great opportunities through our program to volunteer. A big one we have is legal education, and that doesn't just mean for you attorneys legal education, but we do community presentations. So if you're interested in getting out in your community and informing the folks in your area about our services and the ways that they can prepare for the development of dementia over their lives, this is a great way to get involved. Like I said, we do have a statewide footprint, so you can volunteer anywhere in the state through any of our programs. So what exactly is the volunteer opportunity? The big thing that we do is we help clients one-on-one with dementia legal planning services. So that'll be the power of attorney and advance directive documents that Angela will be talking about shortly. And I do want to highlight that we do include malpractice coverage, and you can get CLE credit for volunteering through us. So it's a great opportunity for volunteering. We hope if you have some time, you'll consider helping us out and helping clients across Washington out. The last thing I'm going to highlight before I hand it over is that we do have some current volunteer opportunities coming up. Next week, there's an opportunity. We have a legal clinic in Seattle. We have another one in, or I guess we have another one in Seattle the week after that. So if you're looking to volunteer here in Seattle, please follow up with us. We've got a great, it can be an easy as short as an hour or hour and a half commitment if you're looking for something to participate in that's kind of quick. We're also going to be in Spokane and in Clark County in the next couple months. So let us know if you're interested in one of our clinics. We also can tailor appointments to fit your schedule. And so that can be a really easy way to help out even just from your own office. So I'm going to stop sharing my screen now. And I'm going to hand it over to our presenter for today. Angela Macy-Cushman is an estate disability and long-term care planning attorney and a partner at the Seattle firm of Summers, Tamblin, Eisenhower, Black. She serves on the board of the Washington State Academy of Elder Law Attorneys and the WSBA Elder Law Section's Executive Committee. Angela has taught trusts and estates and the Estate and Disability Planning Clinic at the Seattle University School of Law, and she is a governor-appointed member of the Dementia Action Collaborative. And prior to law, she worked in the field of long-term care as a registered nurse. So we're very lucky to have someone so well qualified here today. And I'll go ahead and turn it over to you, Angela. Thank you and welcome.
Hi, can everybody hear me okay? Michael, can you give me a thumbs up if you're hearing me okay? Okay,
yes.
Great. If it's not, you'll hear my story in a minute about where I am. If it's not, maybe, Michael, if you can jump in and tell me if there's something wrong with my connection. I have my phone ready to switch over technologies if I need to. Michael just did a really nice job introducing me and all these qualifications, but I'll tell you what my most recent qualification is. It is that my mother has dementia, and my mother is at the end of life. And there is nothing like that firsthand experience. Nothing has fully prepared me, despite all of those things Michael just talked about, for dealing with this when it hits your own family. And so I come to you today having some situations going on. I actually have traveled down to Texas to be with my mom at the end of life, and I'm being her hospice caregiver right now, which is very different than being a lawyer, as you guys know. And last night there was a huge storm in Texas. I don't know how much you guys follow Texas news, but I've actually driven to Louisiana today. So I'm in a different house today, so I can bring you this presentation because there's no power at our house. So I say all of this so that you know that, first of all, I really wanted to be here today to talk to you about this because it's really near and dear to my heart and really important to me. And also, it reminded me of that old Southern phrase, God willing and the creeks don't rise. Like I told Michael I wanted to do this presentation, and God willing and the creeks don't rise, I was going to be here. So now the final frontier is just technology. So Michael's going to wave me down. I'm at my brother's home, and you can see the cat toy basket behind me. I'm not in my legal office today, so bear with me. But I see your names out there, and I see a lot of familiar names. That's wonderful. If you have comments as we go through, what I would suggest, since there's so many of us on this meeting today, is that you put your questions in the chat and we save them for the end, unless Michael jumps in and says, hold on, this is a good question that came up that maybe you want to answer now. So Michael, will you do that for me? Otherwise, we'll wait till the end and we'll look at the questions. Thank you. So being a good, lawyer presenter, I made you a slide deck, but I want to have more of a conversation and not just give you a presentation. But let's go through that because I think it'll help you get some confidence and feel like you know what you're doing when it comes to legal planning with somebody who's been diagnosed with dementia, and also their family members. We're going to, also include that conversation too. So if I can share my screen. Oh boy, this is always, when I was teaching too, this is always the scariest moment for me. Let's see. Okay. Are you guys seeing that? Okay. All right. Now I'm going to do the thing where you start the, hold on. I don't know how to do it. I'm just trying to get it to start. Hold on one second here.
You can go down at the bottom
Where?
of the screen.
Yeah, there's this one. Okay. Yeah, got it. Thank you. Michael's like, oh, I wish I could do that for her. All right, guys. So what we're going to talk about today is, just like it says, what every lawyer needs to know about legal planning for people with dementia. When I say every lawyer, I mean literally every lawyer, because it's not just us elder law attorneys who run into people who have a diagnosis of dementia, that we don't just, like, oh, well, you need to go see an elder law attorney then. You're going to, in your practice, run into people who have some, either a diagnosis of dementia or a diagnosis of another condition that's associated with, one of the symptoms, one of the problems that comes along with that diagnosis is dementia. And, that's okay. Like, that doesn't mean that they can't be your client. We're going to talk about that a little bit. But today we're going to talk about it in the context of doing their planning for their, I think of it as kind of being end of life, but it's not just end of life. It's also their power of attorney, their healthcare power of attorney, their healthcare directive. And we'll talk about other planning tools as well. But some of the things I talk about, you can generalize to your other representation to people with dementia. But we're going to talk today specifically about them doing their estate and disability planning and the specific documents that you might be doing through the pro bono work with the clinic or with the pro bono council. So I thought we could just start. Maybe you guys already know all this, but let's just start and talk about what the heck is dementia, because it's a weird word. And, sometimes people go a long time without ever really understanding quite what it is, or maybe have made some assumptions about what it is or isn't. And I want to talk a little bit about whether a person who has a diagnosis of dementia can sign legal documents. I've had clients call and tell me they're trying to get their legal documents done and they've got to meet with me like tomorrow. And I'm always like, I'm not the emergency room. I don't know if I can meet with you tomorrow. What is the urgency? What's going on? And they're like, we have a doctor's appointment day after tomorrow, and we are pretty sure they're going to diagnose me or my wife or, my dad with dementia. And we know, we've already learned that they can't sign any legal documents after that diagnosis. So we've got to get in to see you now. And so let's talk about that a little bit. Let's challenge that idea a little bit today so that that that's not necessarily true. In fact, really not true. And then we're going to talk about those, what I call the life-centered planning documents. And those are the documents that Michael shared in the email earlier that you're going to use as a tool for helping people to do some planning. Those are the durable power of attorney for finances, the durable power of attorney for healthcare, and the healthcare directive. And I'm so glad, that this program provides you with those documents as a starting place. But you may wonder, what do I do if they want to do something a little bit different? And we'll talk about that a little bit. We'll also talk about other planning tools your clients might need. And you may not be the one providing those, but there may be some other planning documents that your clients need, and you may just want to be conversant in understanding what those things are, especially if you are not an estate planning attorney at all. So, some of it might be familiar, but some of it might not be. So let's just start off by talking about, what is dementia? Like, it's such a weird word. I wish we could have picked like almost any other word for what it is, but it's, some people just think of like, oh, it's Alzheimer's disease. And of course, Alzheimer's disease is, the most common, well understood form of dementia. But let's talk about what dementia is more generally. It's a general term for loss of memory, language, problem solving, and other thinking abilities that are severe enough to interfere with daily life. That's not the Oxford, dictionary definition, but it's the Alzheimer's Association's definition. I really like it because it doesn't say in there it's a disorder that keeps you from being able to, that makes you non-decisional, to use a term of art. It doesn't say dementia is a terminal diagnosis. It doesn't say a lot of things that we might assume it means. It's kind of a general blanket term for people who have a condition that is causing, predictable problems with memory or thinking. It's a little different than like a brain injury. So some people might know somebody who, had an automobile accident or something, have a brain injury. And that might be a little bit different because that's like a specific isolated injury to the brain. And dementia is a more global a set of symptoms that kind of differs a little bit from something like just a brain injury or a childbirth injury that happens that is very specific and happened in a moment. Dementia happens over time. And that's why when we talk about, what does it look like in a person, it may be different one day to the next, right? Dementia symptoms can wax and wane. It really depends on how tired you are. Are you a morning person or are you a night person? Some people have more dementia symptoms at different times of day. For some people, it really depends on how much stimulus there is, like how many other things they're trying to deal with at the same time. And for some people, it kind of depends on their mood, frankly. So when you say dementia, it doesn't necessarily mean that the person that you see right in this moment is behaving and having the same limitations that they might be another day. And that becomes really important with legal planning because, sometimes we need to plan for picking times that are the best time, the time when the dementia symptoms are the lowest, when they are the best managed, when there's not as many distractions. Sometimes we as planners need to think ahead and say, oh, this person has dementia, how can we make this interaction the best possible interaction we can for their memory and their ability to process? And other times we need to know that because with dementia, sometimes you catch people on an off day. And it's tricky and it's not something that you want, but every now and then you have to be able to say, I'm really glad we had this meeting. I think we need to have a second follow-up meeting because I feel like maybe I just want to make sure we all are on the same page. And you might say in your own mind, hey, I'm not sure that this person's totally comprehending everything I'm talking about. And I want to make sure they are. And so I'm going to come back at a different day or different time. But dementia isn't a lot of things that people think it is. It's not something that means as soon as you're diagnosed with it that you can no longer make really important decisions, but it certainly does impact your ability to do so. You may know this already, but I just like to go over it. I like to remind myself sometimes, what are the conditions that are associated with cognitive impairment and with dementia? Alzheimer's disease, everybody kind of knows that, right? Because we hear about that a lot. And but there's more. So Parkinson's disease is another diagnosis that may be associated with cognitive impairment, with dementia. It's not always. So, I have friends who are diagnosed with Parkinson's disease with no cognitive limitations right now at all, no memory loss. But they may in the future. So sometimes when we're doing planning for people, it's because they've been diagnosed with a condition associated with dementia. And even though they're not experiencing those symptoms or a lot of those symptoms now, they may anticipate that they may be more likely to in the future. The same with Huntington's disease. That's another condition that's sometimes associated with not just a physical impairment, but also a cognitive impairment. If frontotemporal dementia has been in the news a lot lately, if you follow any kind of like celebrity news, not that I do, but I've heard from other people that Bruce Willis has frontotemporal dementia, and I'm really happy that his family has been vocal about this, because I think it demystifies it. A lot of times when people are diagnosed with something like that, it feels kind of shameful, and people sort of hide that fact and take them out of the community. And it's really nice to see someone like Bruce Willis, from Die Hard, still out there, in the, at least participating, at least his family participating in a conversation about this diagnosis. ALS is another one that's not always, but sometimes associated with memory loss, and also communication difficulties, which are different than dementia, but sometimes go hand in hand and can make it really difficult to do your legal planning. And so sometimes, again, we're not just planning for what symptoms you're having now, but what symptoms you might have in the future. Multiple sclerosis, again, sometimes associated, and sometimes strokes. There's kind of two elements of a stroke. Sometimes the stroke, you've got like, boom, you have a stroke. And so you have an injury to that part of the brain that didn't have enough oxygen for a period of time, but it also increases the likelihood that you'll have a more global dementia and more memory loss that's not just limited to that one little part of your brain, hopefully a little part of your brain. So, you're like, are we going to talk about these documents or not? I really want to talk about this stuff because I feel like this is the stuff. You are lawyers. You can do the documents. I guarantee you can dust off those lawyer skills and go talk to a client and help them, complete documents. But this is the stuff that I think is not necessarily intuitive, because I have the people who call you, they may be surprised that their loved one or that they are still allowed to sign documents. Or you may feel like, well, geez, how do I know if they have capacity to do this? I blame law school for this. When I teach trust in the states and I read the chapter on capacity, I always kind of like wig out a little bit and think like, geez, we're really teaching law students that diminished capacity is like a huge issue. That's like just, litigation waiting to happen. And because all the cases in the Trust in the States book are like, everything that could possibly go wrong when someone signs a legal document, but maybe didn't have full capacity, right? And that seems to be this emphasis. But what I want you to know is that usually it's the other way around. Usually the problems happen because a person did not sign these documents. And I believe that more often than not, there was a window there, between diagnosis, between recognition, and the time that they truly could not sign those documents anymore, when they could have, and for various reasons, including oftentimes, I think, assumptions about whether or not they were allowed to sign those documents, they missed the window. And so what I want to encourage you to do is to think of yourself when you're doing this planning as catching people in the window, and how important that is, and maybe be a little less afraid of a situation where you're like, oh, well, I'm not sure this person, understands their exact bank balance, right? Or I'm not sure this person knows exactly how much they have in their IRA. That's okay. A lot of us don't. That doesn't mean that they aren't able to appoint an agent. So let's go through some of these considerations. And I see a couple of things coming up in the chat, and I don't see what they are, but Michael's going to flag me down if I need to answer questions. First of all, I want you to think about, and everyone who comes to you has been screened. So already someone at Michael's level has determined that this person probably has the capacity to sign legal documents. So you're really blessed in that way. But when they come to you, who knows what's happened between those conversations, or if it's a different day or whatever. ask yourself, did they have the ability to understand the concept of what they're signing? It may be these are legalese, and even the documents that you received, like sometimes, not just because of dementia, but also because of just like fear of legal language. Sometimes people are very intimidated about reading these documents. So before you engage with people, you need to really read them yourselves, so that you can explain like well, this section goes over this and talks about this, and make sure like instead of reading it to the person, because reading it to the person may be one tool. They may ask you to read it to them because they have a hard time reading. But usually what you're trying to do is that more nuanced lawyering of explaining something to someone. So make sure you understand it yourself. And I find that practicing, with somebody really helps, because then you can see like what they ask. Oh, well, does that mean this? Does that mean that? And you kind of get used to answering those questions. It can be really intimidating if you don't do this work a lot, and someone asks you a question about documents they're about to sign. You're like, I don't really know. And that's going to happen anyway. But if you can at least practice beforehand, then as you're explaining it, you'll be able to focus on whether or not they're understanding it versus whether or not you're understanding it. So by familiarizing yourself with the documents, then you can, as you explain things, you can be talking to them and saying, does that make sense? Do you have any questions about that? And really be focused on their understanding. We already talked about this a little bit, and that's, doing a check with yourself about whether you think this might be a waning day of their ability to understand. Sometimes you just catch people at the wrong time. That's true of all of us. I said that before, but it's especially true of people with certain types of dementia, where cognition can be a lot sharper at one part of the day than they are another part of the day. And sometimes I hate to do it because I hate feeling like I'm wasting people's time, and it's like, oh, I'd really rather just get it done. But I really have gotten into the habit of inside having the place where I'm going to call it and say, all right, I'm really glad we had this conversation today. I think we should have a second follow-up conversation. When would be a good time for you, so that we can make sure you understand these documents. If you really feel like this person's not getting this, then, I want to talk to Michael and make sure I understand, but I also think maybe I just caught him on a bad day. Sometimes people will also just tell you you're catching them on a bad day. They might, come to the meeting and be like, oh man, I just went through all this and I went through all that, and it's just, I barely made it to this meeting. So you're going to have to use your judgment. But if you think that someone might not have capacity, instead of just throwing out the baby with the bathwater, consider a second meeting. Second meetings are great because then you can confirm what they said in the first meeting at the same time, what you did accomplish. I always, with these clients that come to you, they may have never done this planning before. But if they have, and they tell you like, oh yeah, I already did one of these back when I had kids, when, back in, the early 90s, I did one of these or whatever. Ask them, oh, who did you appoint in those? Do you have a copy? They may have a copy with them when they tell you that. And it's interesting to ask who they named before, but don't assume they're going to name the same person. Don't even necessarily encourage them to name the same person. But if they're changing it, that's definitely something that, sometimes maybe triggers a little bit of caution, like, oh, well, tell me about that. Before you named your oldest son, but now you're naming, a friend, tell me about your friend and why you want to name her. Because you want to kind of know the story. The time when someone will be more likely to challenge a power of attorney and become a law school fact pattern is sometimes when someone is kind of under the influence of someone who's not part of the family. This this person who that's a perfect fact pattern for law school, right? The neighbor who swoops in and is helping out. And now that person has brought them to a lawyer to sign new documents appointing them. This is rare. But just use your spidey senses, use your good lawyering to think about like, oh, how is this different from before? And even if they didn't have a power of attorney before, for healthcare power of attorney, there's a statutory default, which is kind of like your intestate heirs at law. It's not the same exact, but it's a similar kind of lineup of people who, if you don't have a power of attorney, then the law will assume that's who you wanted. How different is what they're choosing from the statutory lineup? I mean, it can be completely different. That's fine. You know, if they don't want their, I mean, a lot of people really don't want their aging parents to be their agent. A lot of people don't want their, you know, kids or their siblings to be their agent, but talk to them about it. Oh, why did you choose this person? Tell me more about that. And sometimes I even say, you know, if you didn't have a power of attorney for healthcare, this is who would be under the law, but it sounds like you're not choosing that person. And then you'll get a story and you'll understand a little bit more of the context. Um, that's I think that's important lawyering for all planning, but especially for people with dementia, where you know later on they may not remember why they chose that person, or you know you need to have kind of in your record kind of what they told you about their choices. Um, every now and then someone kind of slips through the cracks, where they're there and they're ready to do a planning, but I didn't know ahead of time that somewhere along the way they've been determined to be non-decisional, which I kind of hate this phrase, you know, in some medical record. And if that's the case, you just need to be aware of it. It doesn't, when somebody's non-decisional one day, it doesn't mean they're non-decisional another day. But if someone has had a crisis, if someone has been, you know, at geropsych, you know, at Northwest Hospital, or in certain cases, the family members have swooped in and been trying to help, and they're like, doctor, in order for us to step in and help, we need your letter. And sometimes doctors kind of throw around this phrase, oh, Angela's non-decisional. That can be a challenge for establishing a valid new power of attorney. It's not something I would say you need to ask people, but if you're hearing a lot of stories about like, oh yeah, I was in geropsych and I was, you know, this happened and that happened, then you might want to at least put it on your radar that somewhere along the way in the past this person wasn't technically able, or you know ostensibly wasn't able to sign legal documents. But if they haven't, which most people haven't, you know, they're going to get to you, they haven't been determined to be non-decisional, then assume they are decisional. Don't assume because of a diagnosis, or because they're coming to you through like the dementia legal planning clinic that they can't make decisions. Only, you know, only have those concerns if you're getting clues that it's really an issue for them. For powers of attorney in particular, I make sure that they are selecting an agent. Here's an example. Kathy is the mom and Jimmy is the son. Okay. I just picked the name of a cat that's sitting near me because I remember this one. So Kathy and Jimmy show up, and Kathy has just been diagnosed with Alzheimer's, and they say, oh yeah, we've been seeing this for, you know, a couple of years now. We just now realized what it is, and she needs to appoint me as her attorney in fact. Or they'll just say as her power of attorney. They always think the name of the role is power of attorney. So here, can you please prepare a document that makes me her power of attorney? And you maybe, right? Maybe Jimmy's exactly right. Maybe that is where you're going to end up. But instead of just like saying, okay, well, let's fill out this form, you know, Jimmy, what's your full name? Instead, step back and say, okay, well, let's have a conversation and start at the beginning. Find out who this person is. How many kids do they have? Are they married? Are they in a significant relationship? Who are their people? And if you find that out, instead of saying like, you know, right, like who do you want to be your agent under your power of attorney? You know, that's not a very good way to find out who the characters are in their life. But if you step back, find out who the characters are in someone's life, you can kind of assess their capacity while you're doing that. And when they say, oh, and I really, you know, you say, who do you want to be your agent? And they say, Jimmy, you can, that makes sense, right? Because like, oh, Jimmy is your oldest child, the one who lives near you. Jimmy, you know, your husband also has dementia, and so he can't serve, you know, like you've gotten a little bit of that context, but don't assume that the person sitting next to them or the person who made the appointment is, or even the first person they say, you know, is the right choice. Ask them, say, you know, oh, why'd you pick that person? Tell me about that. So that you can feel confident that they've really been the person to select their own agent. And then, like I said, see who that person is and kind of where they fit into the puzzle. Now, sometimes people will tell you an oddball, you know, like they'll have a family, they'll have adult children. You're thinking, oh, it's going to be one of these three adult children. And then they'll pick somebody who's like a friend. sometimes that is just fine. But I would suggest that if you want to avoid ever hearing from those adult children down the road, or if you do, knowing what what's going to be in your record, make some notes about like, this is the best friend. She's a social worker. They've been friends for 40 years. I mean, whatever it is that supported that person's decision. Take a minute to write it down in the record. And look out. It's not very common, so I don't want to freak you out. I don't want it to be like a law school fact pattern, but do keep like a tiny little, red flag ready to pop up. If it's someone who's like kind of Johnny on the spot, is what I call them, the helping neighbor, someone who may have undue influence, to go back to law school and remind you of those old phrases. We don't want someone else, like the adult children, the family, to be, in a situation where they've just been frozen out by this person, and this person's like toting them around to get updated legal documents. That's very rare, and I think that by the time they get to you, Michael and his team would have sussed those things out. But just, keep it in mind so that you can relax if that's not the situation. Um, Sometimes people have someone else at their meeting, right? So what if Kathy shows up with Jimmy? Kind of weird, right? And it happened a lot in Zoom times for me, where I'd be meeting with somebody over Zoom and we'd be having this conversation. About 40 minutes in, I would see them look off to the side and then nod at me or answer a question. And I would realize, oh my gosh, there's someone sitting right next to them. And if they would move their, computer over a little bit, or I would have realized that there's like somebody coaching them. And so I started with Zoom in 2020, saying, hey, before we get started, tell me everybody who's in the room. And it's amazing how often there's someone else other than the client. If you're working over Zoom, someone else other than the client who's sitting there. Now, sometimes that can be okay, but I like to always have a breakout, some part of the meeting with just the person who's my client, if not the entire meeting. That's my preference. But sometimes they'll say, oh no, I really want Jimmy here. It's important for me that he be here. You and I don't know if Michael and if the program has a policy on this, but sometimes you just can't quite talk them into only having a solo meeting. In those cases, what I do is I say, okay, for part of this meeting, I'm going to need to just talk to you. And I kind of recruit Jimmy or whoever the other person is into it and say, hey, because I want to make sure these are valid documents. What I want to do is have a conversation with just your mom. If you can step out and, if I can just have a conversation. It's a lot easier in person because you can kick them out and send them to the lobby. And the ABA used to publish this, and I've got to get my hands on it, this little pamphlet called Why Am I in the Lobby? And it was something that I think it was especially for estate planners, when you kick somebody out in the lobby, and it would talk about how important it is that the attorney have a conversation directly with the client, even if you're the caregiver, even if you're the helper for the client. So try to have that solo meeting, even if part of your meeting is going to be a joint meeting. Be really cautious when you're having a joint meeting. You're not going to get the same candid responses. And so, really do your best to have a solo meeting when you're having those, like, oh, tell me about your family type conversations. Because when they're answering questions, all of those answers are going to be in the lens of knowing that Jimmy and, whoever else is sitting right next to them. When in doubt, go back to the RPCs, and RPC 1.14 is really helpful. And there's a bunch of explanatory comments, and so I encourage you to go look at the comments too. But I just, I got this from Lisa Brodoff. I'm sure a lot of us have been inspired over the years by Lisa Brodoff. But when in doubt, I go back to this and I read it to myself to remember that if I'm working with a client who has diminished capacity, I need to, as far as reasonably possible, maintain a normal client-lawyer relationship with a client. And that can be hard because sometimes people with diminished capacity come in and they've been in a situation for weeks, months, maybe years, where someone else is speaking for them. And they're used to doctors just talking to that person. Maybe it's their daughter, maybe it's their spouse, like I'll use my mom. My mom was really good at just looking at my dad to answer every question, for the last year or so. And it's hard because it would be so much easier to then just talk to that person, right? That person knows all the information. That person can, schedule the appointments. That would be so much easier. But that is not a normal client-lawyer relationship, to talk to someone else. A normal client-lawyer relationship is to talk to the client. And that's why you have to, even when it's harder, get that other person out of the room, so that you can have, the meaty part of your meeting just with your client, and not, not just to get good information, but to also honor that person and make sure they know that you're not looking for Jimmy's answers. You're looking for their answer. What do they want to do? And, giving them, honestly, that dignity that maybe has been starting to, kind of fall away in some of their other interactions in the world, like at the bank. They may go to the bank and the bank teller just talks to their person, or they may, they may be in a world now where people aren't talking to them directly as much. They're talking kind of over them. But you have an obligation to engage with them as you would any other client, to the fullest extent possible. Now, of course, there's these other things about, like, what do you do if you need to? Sometimes you have to talk to other people. But what I really wanted to emphasize isn't that. It's really emphasizing, like, start by talking to them directly. Ask them what they think. For these planning documents, these are questions that most people can answer. They will know who they trust the most with their money. They will know who they trust the most with their healthcare decisions. You don't need Jimmy to tell you the bank balance, right? You need this person to tell you who they trust and what their wishes are. So to get right down to the documents, the document forms that you guys have are great. I love them. I've used them through this program, and when I have people who call me but I can't get to them, or maybe they can't really afford a lawyer, I send them the Washington Law Help documents. There's a wonderful YouTube video that people can watch themselves. And I tell people, if you're going to use a free document, this is the only one I recommend. There's so many bad ones out there, but these are good, and these tend to work, and they get updated over time, which is really important. But don't just look at the document. I know this is a pain. I know you're like, oh, I didn't want to sign up for going back and reading statutes. I just wanted to help people. Well, take a minute and go back and read the Uniform Power of Attorney Act. It's not hard. It's not going to kill you. It's not just a bunch of esoteric, references to other statutes. It helps you go through and see, what are these powers? What are the default powers? What are the special powers? How does this work? How is it set up? And that will help you understand the document a lot better. Because then when you look at the document, you'll be like, oh yeah, this is why this is here, and this is the order that things are in. Remember that even though you may be drawn to, like, the healthcare decisions, and healthcare power of attorney, and you may be thinking, like, oh, this person doesn't have a whole lot of money. I want to help them have someone to help make decisions about consent to healthcare, or what do they want at the end of life. That's their focus. Why am I bothering with this document about money? It's not just about money. When you go through the Uniform Power of Attorney Act, you'll be reminded, if you haven't looked at it lately, that it's about the ability to contract, the ability to apply for benefits. Honestly, it's hard to apply for benefits for somebody without one of these powers of attorney. They may only have, like, $4,000 in the bank, but $4,000 is $2,000 too much for some of the benefit programs, and they may need someone to help them spend down that money to get eligible. And without a durable power of attorney for finances, you're really faced with a limited number of choices about what to do to help somebody, even if they have very moderate means. Conservatorship is really the only true alternative. Sometimes you can kind of go in, sideways, by having the person there, saying yes or no, but somebody else helping them. Sometimes we can kind of try to work around it, but without a durable power of attorney for finances, there are a lot of situations where unnecessary conservatorships are, clogging up the courts, as they say, because we missed the window. There was time when they could have signed one, but nobody thought it was important enough, or no one thought that it was possible. So you are helping people, not just with their healthcare decisions, but also by getting this durable power of attorney for finances together. Remember, the law doesn't have a default one, right? For healthcare, we do. If I don't have a power of attorney for healthcare and I can't consent or refuse healthcare, and the doctor's looking around, if they can't find anybody who says, "Oh, I'm the agent under this power of attorney," they've got a nice little statute they can start reading down, right, to figure out who they can, accept, who they can talk to, and who can give consent or make healthcare decisions. Not so with finances. So you don't want to just, you don't want to skip over this one, is what I'm trying to get at. Sometimes it helps to ask if someone's already in this role. You remember Jimmy and Kathy? It may be that Jimmy brought Kathy, Jimmy, the adult son, and Kathy, the mom who's been diagnosed. Maybe Jimmy, got mom to come to this program and got Kathy in front of you. But maybe, Sister Susie has been the one who's actually been doing the work, and Jimmy just flew into town and was like, "We got to take care of this." So a really important question is, who's already doing this kind of stuff? If they have someone who's already been helping them, and sometimes that's a good choice, and sometimes it's not a good choice. But it's really helpful to know what's been going on before they got to you. If they needed someone to assist with managing finances. And if they choose someone as an agent who's not that person, then you're like, "Oh, that's interesting. Why not? Tell me about that." What I like to do is, people say, "Oh, I don't need one of those. I'm just here for the healthcare power of attorney." I like to say, "Oh, what's great about this is it allows you to officially select someone. You may have kind of an arrangement, worked out, and may be working fine. But if in the future, you need someone to step into this role, you don't want the court to just pick somebody. You want to pick the person. So even if you feel like you don't need this, who would you pick? Who would you trust?" And I think I'm hammering this sufficiently, but I try to avoid saying things like, "Hey, I'm gonna name your sister Carol because you said you have a sister, Carol, and it sounds like she's the only person around who lives close to you. So I'm going to go ahead and name her as your agent. Is that okay?" What's somebody going to say when the lawyer, and maybe they've never even seen a lawyer before, the lawyer is leaning in and about to write something and is nodding and just wants you to nod, right? They're going to say yes. Instead, you're getting a much better answer if you ask the question, "Hey, who do you trust most to help you with your finances if you can't do this for yourself in the future, or if you need help?" And if she says, "Oh, well, Carol," then you can have a lot of confidence in that response. There's some nuances to the durable power of attorney for finances, and one is that there's a difference between springing powers and immediate powers. I am biased. I tend to recommend to people that if they have someone they really trust, that they make their powers immediate. And I used to be agnostic. I used to say, "Oh, it's completely up to you and it doesn't make any difference, whatever you feel comfortable with." But then I've had so many families come back and say, "We're trying to help, but she's, she doesn't want to go get a letter from the doctor saying she's incapacitated," which is what would be required for springing powers. But she really needs someone to help her. But when we go to the bank, the bank is like, "You need this letter from the doctor." So the power, or the benefit of immediate powers is that it doesn't require the principal, your client, to be, have a doctor's note saying this person cannot manage their own finances. The person could start taking advantage of the assistance earlier on. There's a counter argument to that. And I don't want to poo-poo it. And that's that sometimes you do not want your agent to start acting, even a second before you want them to. And sometimes people, especially people who've been independent, they don't have close family members. They don't want the person they name to step in and start acting even a minute before they have to. And so I always tell people about the two options. So when people say, "Well, what's the best?" I say, "Well, if you really trust the person, immediate is best. And if you don't really trust the person, is there somebody else that you would trust? Do you have the right person here?" But sometimes even when you have that full conversation, people still feel more confident signing this document if it's springing, meaning it's only effective when they have a doctor's letter saying that they can no longer manage their finances. Another nuance is a power of attorney with limitations versus one that I call the kitchen sink power of attorney. Like every power we can possibly come up with. That's the kitchen sink expansive document. In the form that you guys use, there's like some yes nos, and those are the special powers. They have to affirmatively say that they give people these powers. When you're going through those, I encourage you to talk about it holistically, to say, if this is somebody you really trust, then one option is to give them all of the powers we could possibly give them, so that no matter what comes up, they'll be able to act in your best interest. But if you sense hesitation, if they're like, well, I want them to help me, but I'm not sure, I don't want them to do something like screw up my estate plan or something like that, then as you're going through those yes nos, you can have a more nuanced conversation. The problem is that when you're having a conversation about like, do I want someone to be able to direct funds to a trust in my name, or establish and fund a trust in my name? Most people will say, of course I don't. Like, why are they doing that? I don't need them to do that. I just need them to help me with a bank account. The thing is, they may not, no matter whether they have dementia or not, they may not be able to understand why in the future someone might need to be able to do these things. And so they should take the limitations. When they say, no, I don't grant this power, they need to understand that may cause problems down the road in terms of that person not being able to do things they need to be able to do for the person. So, it's hard. It's not just black and white, but I would encourage you to not say like, well, each one of these things, like, would you want somebody to be able, to do this thing for you, without being able to talk about like why someone in the future might need to be able to do these things for you. And if that's not comfortable, to at least be able to talk about like, hey, one of the benefits of this document is that we can give them powers to do things we can't even come up with right now, so that they can act in your best interest in the future to do those things if they need to. All of it has to be about their best interest. Sometimes people are like, okay, I want to name all 4 of my nieces as my agents. And they've come in, they thought about it ahead of time. Sometimes you ask them, they're like, oh, well, how about my 4 nieces? Those are easier. It's the people who they've already decided they want all 4 of their nieces. Co-agents are problematic. I mean, it's not problematic for you because it doesn't take you that much more time to type 4 names versus 1 name. Like, you can make a document that says that, no problemo. It's the other side of the coin when they try to take that document to the bank, or when there's a disagreement about what to do for, Aunt Rosie or whatever the situation is. So there's a too many cooks in the kitchen problem that crops up a lot more commonly than things like undue influence and all of those things you read about in textbooks are not very common. Problems with co-agents are very common. Even if the document says each of those 4 nieces can act independently, banks will be like, no. If you want us to do anything, like open an account, close an account, transfer assets, we want all 4 of these people to sign off on that. And we don't care what the document says. We're going to require it as our policy. So, encourage people, if they can, instead of having all 4 nieces, maybe pick 1 niece and then a backup, and they can even have 2 more backups, and have them like in line instead of having a power of attorney that names them all as like one big, scrum of decision makers, because that does become really challenging. And also, and I won't go into this too deeply because I think that the form you guys get, Michael, does it come with a revocation form?
Yes,
Yeah.
as a
Okay.
revocation.
So you have to remind people like, hey, you can revoke this. And like, here's this document. If you need to revoke this, you can. This is your document. And sometimes that helps give people confidence. I don't actually have people revoking them very often, but it comes up in conversation a lot that people want to know, like, once I do this, what does that mean? And I always encourage people to say, hey, if things change, then you need to update your power of attorney, and you need to be thinking about that, not putting it off if you need to update it. Um, Before we move on to the next one, Michael, are there any questions from the group that you want me to? I see there's a couple of things in the chat, but I don't want to
There's
open it and lose my
one
flow here.
one question in the chat. What are your thoughts on combined finances medical DPOAs? Any reason to keep them separate if the same agent is named for both?
Well, whoever asked that, thank you. That was such a nice slow pitch. Thank you, because we're going to talk about the durable power of attorney for healthcare, and you may be like, I have one, or my mom has one, or I've seen them where it's just combined. Isn't that a lot easier? And yeah, I mean, for some people, having one document is handy because it's just literally one document to keep track of. But here's the problem. Let's talk about Kathy again. Kathy, who do you want to be your agent for your financial decisions and your healthcare decisions? Well, I just asked it in a way that's convenient for me because I want to have a nice little one document, like one-stop shop, and I just want them to pick one person, right, for both. But it would be a lot better, and what I try to do in my practice is ask one set of questions about finances first, and I even say, like, we're going to talk about healthcare in a couple of minutes because I know that might be a different person that you pick for that. But let's talk about finances first. And then separately, I complete, a call, I say, now let's talk about healthcare decisions. This might be whether or not to consent to a procedure if you're unconscious and can't consent yourself. If you're, going through treatment and they're considering transferring you to a different setting, somebody who could participate in the conversation about where you might transfer to. I give them lots of examples about healthcare decisions, and then I say, who in your life would you trust to make healthcare decisions? And I've completely detached it from the financial decisions. And of course, if you want to know who taught me that, it's good old Lisa Brodoff. Because if you ask it the way I said earlier, like who would you pick for your financial and healthcare decisions, you're going to get a person who, if you'd asked it differently, they may not have named that person for both roles. They may have said, oh yeah, Jimmy for my finances, sure thing. I really want Jimmy for my finances. For my healthcare, I want my daughter, Karen. She's a nurse. She is always going to my medical appointments with me. Like, but I wouldn't trust her with my finances, over my dead body. Like it might not be. In fact, it's often not the same person who's the top of the list for both powers. So if they're different, then it's very confusing to have it as one combined document. The forms that you have for this program are separate, and I think that makes a lot of sense. Out in the world, you'll see combined powers of attorney, and I just hope that the attorney to help prepare those asked those questions separately. They just had the same answers for both powers, and so they were able to combine that into one document. But in your mind, as you're going through these, I encourage you to think about these as being completely distinct documents and asking the questions so that they're not trying to answer both at the same time. You can take a look at the RCWs again. This one has a couple of RCWs that I want you to look at because part of it's like the Uniform Power of Attorney Act that we already talked about, but also the informed consent RCW that I cited here tells you like who will, that law imposed lineup of people. And sometimes when people see that lineup, they're like, whoa, that is not who I would pick. Like, I'm married, but I haven't talked to, I've been separated from my spouse. We don't live together. I wouldn't want him to make any of my decisions. They'll tell you things like that if you tell them what the lineup is in the law. It's very common that people would pick someone who is not the default. But I just want you to know there is a default. I didn't bring this up earlier, but I think it's important to bring up now. In neither of these powers of attorney does it grant the agent the power to jump over what the principal wants. So this is, very controversial. There's right now in the state legislature some, push to try to clarify this because it comes up sometimes. People who are acting as the agent under a power of attorney sometimes think that they have a power to cancel out the decisions of the principal and override the decisions of the principal. That's not correct. The power of attorney, you are acting at the person's behest, and as soon as they don't want you to anymore, they can fire you. And healthcare providers get kind of like, put in a sticky position, right? Because sometimes it would be a lot easier to just go with what the agent is saying versus what the principal's saying, like that's complicated. And so sometimes we have to, as lawyers, be on the lookout for that. In your role here, what you need to do is make sure you're assuring people that under the law, they're not having any of their own powers taken away, like in a guardianship or conservatorship. They're granting someone else the ability to step into their shoes at their request. And they can't come in. I said curtain. I meant curtail. Sorry about that. They can't curtain any. I'll start using that word as a verb. They can't curtail any of the person's own rights under a power of attorney. A cousin document of the healthcare power of attorney is the healthcare directive, and a lot of people call that a living will. It's a document that it has an RCW, and there's a kind of a form provided in the statute, but it's a constitutional right. It's not a statutory right. And so the form of that statute is not the only way to accomplish making a directive. Like, we have the constitutional right now to say what we would want in certain, instances in the future if we can't make that decision at that time. There are some limitations on that. We can't use a healthcare directive or a power of attorney to use the Death with Dignity Act. That's actually prohibited. So we can't say in our healthcare directive, like, oh, if I'm diagnosed as being terminal, then even if I can't communicate my wishes, I want you to, use the Death with Dignity Act. Because of the way the law is set up for death with dignity, you have to be able to do that yourself at that time. But short of that, you can say now, you can make a lot of choices now about what you would want in the future. And the way the statute is set up, it's like at the end of life, like, in that time when that awful family meeting happens where the doctors say, hey, she's not waking up from this. We've done all these tests, she's in a permanent unconscious condition. We can keep her on IVs and, keep her going for a while, but what does she want? What do you want to do here? That is a panic inducing moment. And if there is a healthcare directive, it gives the decision makers, the healthcare providers, but also your own agents, something to look to say, what did they want in this circumstance? For dementia, there might be a lot of other decisions in addition to just like end of life decisions that they may want to make now. Like, hey, if I need to be in care outside the home, I would prefer this type of care. If I can't, these are people I would want to be allowed to visit me, and these are people I wouldn't want to be allowed to visit me. You can make a lot of decisions in advance that aren't just those end of life decisions. I will say, the more out of the box you get, the less likely it is to be enforced. So what I do, and this is open for debate and discussion. My strategy as a private practitioner is to give people kind of the form, where you guys are going to start with, like, here's the form. How can we customize this to make it fit your wishes? Instead of saying, what are all your wishes? And then let's try to put them into like a document that looks like a legal form. If people are interested in doing that process, there are some programs. One is called Speaking of Dying, that's run here in Seattle. Another one is the 5 Wishes. It's a little bit of a longer, more narrative way. So if people really want to engage in a process of thinking about what they want their end of life to look like, maybe you do the directive that you have with them, and then later, give them some referrals, like, oh, hey, I wanted you to know about Speaking of Dying. You might like this program, but you might not be able to accomplish all of that with this particular form. I encourage people to avoid algorithms. You'll see this with engineers. Engineers are like, well, if I get to a point where I have stage 4 Alzheimer's, like they're really clinical, if I have stage 4, and if I can't eat, and I'm turning down foods, and I don't want anybody to feed me anymore. So he's like trying to create this algorithm Or, I can use this example. If I can't recognize my husband, then just let me die. People say, if I can't do this, if I can't do that, just let me die. And I get that. I understand the sentiment, but how enforceable is that? Like, oh, well, you know what? Angela didn't recognize Chris today when he came to visit, so I guess we're just gonna let her die. What does that mean? That's not very enforceable. It's not very helpful. It's not going to actually result in them getting what their wishes honored, right? So instead, help them answer the question of like, what's most important to you? Like if somebody's trying to make end of life decisions for you, what would you want them to know about your value? And they might say, oh gosh, spending quality time with my husband is the most important thing to me. My ability to have, interactions with him is, what makes life worth living. Um, you know, that's the kind of conversation that leads to directives that actually are helpful. Because then if someone's like, wow, we're getting to a point where, mom can't do anything anymore, and we're being asked to make these end of life decisions. How do we know what to do? We can look to those value statements to help understand how she might have made that decision if she were making it now. These directives are kind of not worth the paper they're printed on if nobody knows about them. So it's not just, we talk about the attorney-client privilege and having these documents and, talking about them in confidence. But once you have them, especially with a directive, you need to, this little light of mine, I'm going to let it shine. You need to make sure people know what your directive is. And having those conversations is just as important in planning as having a piece of paper that says it. So once they have a directive, it's important to tell people like, now make sure the people who need to have this have it. Take it to your healthcare provider, give it to your healthcare power of attorney, and make sure you talk about like what would you want in different scenarios, because they're going to have to make decisions that aren't going to be just like yes, no. It's going to be a lot more nuanced than that, and they're going to be like, what did Angela say about that? And you want to have had that conversation. Other important planning tools.
Hey,
Michael, how much
Angela,
more time
sorry,
do we have?
just
Yeah.
yeah, we're actually up on time now, but I think
Okay.
you're welcome to keep going. I just want to let everyone know we are recording, so if you can't stay, go ahead and catch the recording of whatever's left. We have a couple questions we'll hopefully get to.
Okay.
And for CLE credit, we will be sending out an email. Please complete the form if you're looking for credit, but keep going, Angela. I would say
Okay. Okay. Well,
maybe
here,
just go
if
through
you
and
have
we'll have
questions, if anybody wants to follow up, feel free to email me. If you have questions, I'd be happy to talk. And I'm sorry we didn't have a chance to discuss today. But just briefly, you'll hear people saying like, I thought I was going to do a will. My daughter said I was calling this number so I could have a will. Wills are important, but I would say all the documents we've just talked about are actually more important for most of the people who have a diagnosis of dementia, and because they're going to matter in their lifetime, right? A will doesn't really matter when we're alive, but it might matter to there are other people who are really important to them. But you might find that people are asking for wills, and you might need to talk to Michael about making good referrals. Another document is instructions regarding disposition of remains. They may need a special needs trust. There may be these other things that they need, but you can kick that back up to Michael to find out how they could access those resources. I would never say like, oh, it sounds like you're in the wrong place, because we don't do that. I would say these things we're doing are the bedrock of good planning, and the other things you may do that also. But let's make sure we get these really important documents done, and let's make sure you talk to your family or your friends or people in your life about what your choices are. I just included a few links that I think are really helpful. We all know the Washington Law Help one, but I like to also look at the End of Life Washington, their directive and how that's set up. And then I go to this, this What is Dementia website sometimes for like language, how to talk about things, and it might be helpful for you. So I'm sorry I didn't time this out to leave enough time. I start talking, I just can't stop. But I do have time right now if anybody wants to ask some questions, and I'll stop the share.
Great. We do have a couple questions in the chat. One, I think regarding POA for finances. You said the client knows who they trust with their money. What if the client suffers from chronic delusions about the person they would normally be appointing as their agent, like their spouse? For example, delusions that the husband is having affairs and giving money to many mistresses. So the patient may tell the attorney she doesn't trust that person.
Yeah, that's that like makes me go, oh, what does that chapter in the law school book have to say about delusions? You need to talk to them in a time, when they're least likely to be having delusions. Hopefully, if somebody seems to be saying things where you're like, that doesn't quite track, right? Maybe that's one of those times where you say, "Great, I'm glad we had this conversation. I suggest we, like I'm gonna kind of break here, and then maybe we need to schedule a follow-up meeting, and maybe that gives you a chance to go back and talk to Michael and his team, because those can be some nuanced issues that might not be appropriate for this. They may have decided that their spouse really is trying to, do something. They're not to be trusted. That may be completely legitimate. But if that is the case, then they may need to engage with a different level of estate planning than than this program, because that's way more likely to be challenged later on, right? Like if the husband is not the agent, and it's because there was this suspicion that he was, doing all these nefarious things, that's more likely to lead to litigation. And then you're helping them if you get them maybe pointed to somebody who does this for a living and can do all the documentation that's necessary. So definitely be on the lookout for things that don't quite track. Like that seems like, that doesn't quite make sense. I've had clients though who do have delusions. I have a client who is pretty sure that her dad invented the computer. And she's told me about this a million times. But she's still one of my favorite clients. And like on other things, she's not delusional. And maybe her dad did invent the computer. I don't know. But I don't know that I believe everything she tells me. But that doesn't mean that I don't trust her when we talk about decisions that she's made for her planning.
And then I guess the other one isn't really a question, but someone posted that one thing they found over the years is that before signing, it can pay to check the potential attorney in fact's name through Odyssey in the courts. They've run across a number of proposed agents that are convicted felons, some for theft, some for abuse.
Yeah, and that's a great idea. Just to take a minute and check that. And if you find a hit, maybe you don't address it directly. Maybe you call Michael and talk to him about it. You might not want to do. It may give you a minute though to say, "Oh, tell me about your niece." Tell me more. Oh, to do this, she'd have to be able to open a bank account. Is there any reason why, sometimes people who've gone through bankruptcy or have had financial problems themselves wouldn't be a good financial agent? Sometimes it makes you kind of ask questions differently to see if they'll kind of acknowledge it rather than you saying, well, I just looked her up on Odyssey and your niece, she's got a rap sheet a mile long. Maybe instead you talk about what makes for a good agent and emphasize that a little bit. And if you're not confident, if it's like, whoa, this person really shouldn't be the agent, maybe that's a thing to take back up to Michael.
I guess thank you everyone very much for attending. And thank you so much, Angela, for this great presentation.